Judge Stickman's judgment dismissing Governor Wolf's motion for a stay of Judge Stickman's original judgment is as powerful as the original judgment, and if you don't know what I just said, stick around to the end of this vlog, and you will. Viva Frei, Montreal litigator turned YouTuber, and last week I did a vlog breaking down the judgment of one Judge William S. Stickman IV coming out of the state of Pennsylvania, granting plaintiffs' motion to declare unconstitutional certain lockdown measures imposed by the government of Pennsylvania. The judgment was a thing of beauty. If you haven't seen that vlog, I'm going to link it right here, but here is a highlight just to give you an idea of what we discussed in that vlog. The opinion was rendered by one William S. Stickman IV, and the judgment is as majestic a read as his name.
William S. Stickman IV.
And you know what? I just went to this guy's Wikipedia page to see who he was appointed by. I had no idea he was appointed by Donald Trump, but I had no idea he was my age. This guy is 41 years old. And now that I know that this judge is 41 years old, I am 41 years old, I don't know what to think. This judgment is wise beyond its years, and I tend to think that 41-year-olds are, a little immature at times. And during my most recent weekly live stream with the great Robert Barnes, I asked him what he thought of the judgment. He said that if he were the state of Pennsylvania, he would not appeal the decision, but that the state of Pennsylvania probably will appeal the decision.
If I was the state of Pennsylvania, I would not appeal. But even though they're locked in at that point, I think they will appeal because they're arrogant.
Well, Robert Barnes is right yet again. Not only is the governor of Pennsylvania, Governor Wolf, appealing the decision, but last week he filed a motion to stay the original judgment from Judge Stickman. And this is where things get a little procedurally complicated, but I'm going to simplify it for you so that you can understand it. My voice just cracked. I am going through puberty.
At 41 years old, apparently.
Sorry, it's league night. I couldn't give a lane to my own mother.
I have no son.
Judge Stickman rendered his decision after a full hearing on plaintiff's motion for declaratory judgment. And we will come back to this a little later in the vlog, but that means there was in fact a full hearing. Witnesses were heard, the parties adduced all the evidence they wanted to adduce, and the judge rendered his decision. Governor Wolf announced his intention to appeal Judge Stickman's decision, and in the interim he said, well, whoa, you've got to stay your decision. You've got to suspend your decision while we appeal it, otherwise our appeal is going to sort of be without object. So Governor Wolf filed what is called a motion for a stay of judgment, and it basically means while we appeal the judgment at issue, do not execute that judgment, suspend the execution of that judgment pending our appeal of it. And Judge Stickman just rendered his decision on Governor Wolf's motion for a stay of Judge Stickman's original judgment, and that judgment itself is as glorious as his original judgment. Now, full disclosure, I was not able to get my hands on a copy of Governor Wolf's motion for a stay, and I don't really think I need to, not because it would be useless to read, but because I can get the essence of Governor Wolf's motion for a stay from Judge Stickman's judgment. That, and you can pretty much anticipate, or at the very least predict, what would have been in that motion, because it's sort of par for the course with this type of procedure. So with that said, let's go over Judge Stickman's judgment because it really addresses some very serious issues. Memorandum Order. On September 14, 2020, the court entered an order and opinion granting declaratory judgment in favor of some of the plaintiffs and holding that certain elements of defendants' COVID-19 mitigation orders violated the First and 14th Amendments to the United States Constitution. Defendants have moved for the court to stay its judgment pending appeal. For the reasons set forth below, the motion to stay is
denied.
The court then goes on to discuss the standard of review just to understand and appreciate what are going to be the criteria to apply to the governor's motion. A district court may stay a judgment pending appeal pursuant to Federal Rule of Civil Procedure 62. Granting such a stay is committed to the discretion of a district court. The party requesting the stay bears the burden of demonstrating that a stay is appropriate. The factors for determining whether a stay is appropriate include the following. 1. Whether the stay applicant has made a strong showing that it is likely to succeed on the merits. 2. Whether the applicant will be irreparably injured absent a stay. 3. Whether issuance of the stay will substantially injure the other parties interested in the proceeding. And 4. Where the public interest lies. The most important factors are the first two. As to the first factor, a strong showing of the likelihood of success exists if there is, quote, a reasonable chance or probability of winning. Quote, while it is not enough that the chance of success on the merits be better than negligible, the likelihood of winning on appeal need not be more likely than not, end quote. To satisfy the second factor, the movement must demonstrate that, quote, irreparable injury is likely, not merely possible, in the absence of a stay. And given that the judge is highlighting these first two criteria, you can sort of anticipate already where he is going to go, but my goodness, he goes there and beyond. Likely is understood to mean more apt to occur than not. To establish irreparable injury, the movement, quote, must demonstrate an injury that is neither remote nor speculative, but actual and imminent. Upon satisfaction of the first two factors, courts assess the harm to the opposite parties and weigh the public interest. Judge Stickman then raises what I think is the most salient salient point of the entire decision, and it's a distinction that everyone has to understand and appreciate when having a discussion as relates to the precedent set by other courts. First, it is important to note that the court's judgment did not arise out of proceedings on a temporary restraining order or even a preliminary injunction, but rather the parties had the opportunity to develop a full evidentiary record under Rule 57. Despite this opportunity, defendants did not proffer any specific evidence to differentiate between the danger allegedly posed by gatherings governed by specific numeric limitations and gatherings governed by occupancy limitations. The appellate court will be bound by the same record upon which the court premised its decision. Despite defendants having every opportunity to make a record, there is simply no evidence that would justify, from a constitutional perspective, the disparate treatment of gatherings. This distinction between a full evidentiary record and an incomplete evidentiary record is essential to understand when trying to distinguish this case from other precedent on the subjects. The other decisions that people are referring to as the precedents on the issue are coming out of the Court of Appeals, but they relate to appeals of injunctions or temporary restraining orders that were denied. And what is critical to understand, in those contexts, one does not have a full evidentiary record. Necessarily, by definition, on an injunction or a temporary restraining order, you do not have a full evidentiary record. The parties have not made all the evidence they're going to make in that file. Those types of hearing, by their very nature, are urgent, they are rushed, they are not based on a full record, they are based on the evidence as it exists at the time, which is necessarily incomplete, and the courts just do their best with that information. In the situation with Judge Stickman, the parties made all their evidence that they were ever going to make in the context of that file. It wasn't a temporary restraining order, it wasn't an injunction, the parties made all their evidence. The parties made all of their evidence, expert and other. The judge heard all of their evidence, expert and other, and came to the conclusion that the plaintiffs made their case and the defendants did not make their case whatsoever. The judge rendered his decision after having heard all of the evidence, which is not the case in the temporary restraining order or injunction cases that we saw coming out of the state of California, for example. The lack of record support for the distinction between the numeric and percentage limitations, as well as the consensus between the court's decision and those of other courts facing the same issue, lead the court to hold that defendants have failed to establish even a minimal likelihood of success on the merits of the First Amendment issue. As a final note on this factor, defendants contend that the court's decision created a split of authority among Pennsylvania state and federal courts that have addressed COVID-19 restrictions, and that split of authority weighs in favor of finding a likelihood of success on the merits. Defendants' position compares cases that, while facially similar, are not procedurally comparable. In Benner versus Wolf, the district court addressed several of the same issues in this case, but procedurally, the decision in Benner was a denial of a temporary restraining order. There, the threshold question was whether the plaintiffs had a reasonable likelihood of success on the merits. This case is a judgment on the merits after the development of a full evidentiary record. The court was not predicting an ultimate outcome, but, informed by a full record, made the ultimate determination.
Oh, snap.
And the decision gets even better after distinguishing this case from all the other cases by highlighting the fact that he had a full evidentiary record. He then goes on to address how the defendants will not stand any irreparable harm based on their own evidence. The court is not convinced that the evidence of record supports defendants' contention that irreparable harm will result if a stay is not imposed. To demonstrate irreparable injury, defendants must demonstrate, quote, harm that cannot be prevented or fully rectified by a successful appeal. And then, relying on defendants' own evidence, the judge goes on to conclude as follows. The harms defendant assert are highly speculative in light of the record, a record that they had every opportunity to develop. Defendants contend that they, quote, are in the midst of managing and mitigating a global health crisis, and the court's decision makes it, quote, difficult for them, quote, to develop ongoing mitigation efforts while at the same time creating, quote, uncertainty, confusion, and danger for Pennsylvanians. According to defendants, the court's decision has stripped them of their, quote, ability to adjust to an uncertain future. They go so far as to posit that, quote, eliminating the congregate limits during the pendency of the appeal
Will result in people's deaths.
It is their contention that, quote, super spreader events where large numbers of people gather, are driving the spread of this disease, end quote, and they point the court to information not entered into evidence during or after the declaratory judgment proceedings. And this is what I mean by not needing to read the governor's motion, is that you get a good idea of it from the judgment because the judgment itself quotes from the motion itself. Apparently invoking evidence they didn't actually adduce during the hearing, the judge quickly brings them back to the evidence they did in fact adduce during the hearing. From a different perspective, not only does the record not support the suggestion of immediate and irreparable harm if defendants may not impose numeric limitations on certain gatherings, but their actions actually show the opposite, that they do not believe that gatherings exceeding their numeric caps will necessarily cause such harm. For example, to avoid litigation in the Pennsylvania Commonwealth Court, defendants entered a confidential settlement agreement permitting a large event to take place in Carlisle, Cumberland County. Spring Carlisle, a large gathering featuring an automotive flea market and auction. Defendants agreed to allow the event to proceed with an indoor occupancy of, quote, the lesser of 250 individuals or 50% of the maximum building occupancy, end quote. This limit is 10 times higher than the 25-person cap on gatherings imposed by defendants' July 15, 2020 order.
But wait! There's more! Hang on to your seat, baby! Cause this one's a screamer!
Defendants imposed an outdoor limitation on the event of, quote, no more than 20,000 individuals, which is 50% of its capacity. This is nearly 100 times the permissible outdoor gathering limit of 250. The confidential agreement also required the event's sponsor to, quote, enforce all applicable social distancing, masking, area cleaning, and hygiene requirements. Now, some people might not fully appreciate the hypocrisy or the inconsistency in the governor's position, but they are in front of the judge arguing that people literally will die if this order is not stayed pending an appeal, while they entered into a confidential agreement that defied their own orders in order to avoid litigation. And Judge Stickman is coming to the conclusion that not only is their position not supported by their own evidence, it is utterly contradicted by their own conduct. And just in case anyone had any lingering doubts, the judge does not stop there. The protests that swept across the Commonwealth throughout the summer are another example of where the record dispels defendants' suggestion of immediate and irreparable harm if they cannot impose specific numeric limitations. While the plain language of defendants' orders makes no allowance for protests, defendants' own actions and the statements of their witnesses show that they do not view that type of gathering as posing a risk of immediate and irreparable harm. Governor Wolf, for example, personally participated in a large protest. The photo of that protest does not indicate that social distancing requirements were honored or enforced. Defendants' treatment of Spring Carlisle and the large public protests across the Commonwealth undermine their current argument that imminent and irreparable harm will occur absent their ability to impose numeric occupancy caps. The fully developed record offers no explanation or support for defendants' argument that people can gather in restaurants and businesses across the Commonwealth based on occupancy limitations. That Spring Carlisle can proceed based on occupancy limitations, recognizing it would draw numbers far exceeding the numeric caps, and that protests can occur with no limit but encouraging masks and social distancing, but that the inability to cap some gatherings in some locations for some purposes will cause the superspread of COVID-19 and lead to immediate and irreparable harm. A judge cannot really be more clear than that, and then Judge Stickman goes on to address the public interest factor. Finally, the public interest weighs against a stay. Defendants' brief argument as to the public interest factor largely mirrors their argument as to irreparable harm. As explained above, however, the record does not support their contention on that factor, nor does the record support a contention that the public interest will be harmed if a stay is not imposed. Rather, the public interest will be harmed if a stay is imposed. The public has an interest in constitutional governance and, more specifically, not being subject to unconstitutional governmental action. After carefully considering the parties' arguments in light of the extensive record, the court declared that elements of defendants' orders violated the rights guaranteed by the First and 14th Amendments. The Constitution is the law of the land and protects the right of all citizens. The public interest would be ill-served if the court would grant a stay allowing the unconstitutional measures to remain in place. So that is the decision. It looks like Governor Wolf is in fact going to appeal the decision, but at the very least, while he appeals the decision, he will not get a stay of the decision. And as a final observation, it is in fact worth noting that 68% of the COVID deaths in Pennsylvania came from nursing or personal care homes. It's in fact such a big problem that the U.S. Justice Department is looking into it. U.S. Justice Department sends letter to Governor Tom Wolf seeking data about coronavirus nursing home deaths. The Justice Department is seeking coronavirus data about, quote, orders which may have resulted in the deaths of thousands of elderly nursing home residents, sending letters Wednesday to the governors of New York, New Jersey, Pennsylvania, and Michigan. Officials say Wednesday that the Justice Department's Civil Rights Division is evaluating whether to initiate investigations under a federal law that protects the rights of people in state-run nursing homes and other facilities. Prosecutors are trying to determine whether state orders requiring admission of COVID-19 patients to nursing homes could have led to deaths. And these numbers are not much better in Quebec or Canada. In Quebec, over 70% of the deaths occurred in long-term healthcare facilities, and in Canada, it's over 80%. And all of this discussion is not really a question of pointing fingers. It is only a question of assessing the effectiveness, the narrow, tailored nature of the measures actually being implemented, and the constitutionality of the measures being implemented. Does it make sense to impose draconian and unconstitutional limits only to enter into confidential settlements that break those very limits, or very public events that break those limits? Well, Judge Stickman says no.
You shall not pass!
And all of this talk has got me sweating like an absolute beast. So with that said, if you like my videos and like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Subscribestar, Patreon, YouTube membership, merch. We've got lots of merch. There will be less sweat on your merch than on mine. But more important than all of that, take care of yourselves, check in on your friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah.